And it's a Rembrandt to the
Brownie, we are ready. Yeah, ma'am. All right, just
Good afternoon, ladies and gentlemen, and thank you for joining us as we update the country through you about some projects on which we have been working. It is hoped that at the end of our press conference today, you'll be more informed about the work we're doing here at the OUR. My name is Elizabeth Bennett Marsh, the OUR's Public Education Specialist. At this time, please allow me to introduce members of the head table, beginning with my immediate left and moving to her left and so on. Mrs. Yvonne Brenham-Nicholson, she's our Director of Consumer and Public Affairs. Mr. Houghton Heron, he's our Deputy Director General. Mr. Marie Chavez is our Director General. Ms. Sherry Lewis is our General Counsel. And Mr. Ansel Hewitt, who is the Director of the Regulation, Policy Monitoring and Enforcement Unit at the OUR. As you can see from your program, there will be a few presentations, after which we'll open the floor to take your questions. I now invite our Director of Consumer and Public Affairs, Yvonne Brenham-Nicholson, to extend our formal welcome.
thank you, Liz. Madam Moderator, members of the office, OUR colleagues, or media partners, ladies and gentlemen, it certainly gives me great pleasure to bid you a warm welcome to the OUR. We're happy to be your hosts on this occasion, where we seek to follow through on our commitment.
Just welcome Shadow.
Welcome to the OUR, as I said before. We're happy to be your hosts on this occasion, where we seek to follow through on our commitment to properly provide an update to the nation about the organization's execution of the OUR's various projects. To you, our media partners, we're mindful of the heavy responsibility you yourselves bear in ensuring that the information we will supply today will be treated with balance and fairness. I know you're here for the main attraction, which clearly is not me, so I will stand down. But allow me to pave the way by paying tribute to the industry and high level of professionalism of our staff members, who have worked tirelessly with the singular aim of ensuring that Jamaican consumers have access to affordable electricity. Ladies and gentlemen, welcome.
Thank you very much, Yvonne. And as you can see, our presentations will be made at the request of the media from the head table today. He perhaps may strike you as a man of not many words. It does not mean, however, that he's not busy working very hard for the benefit of the country. So at this time, I'd like to invite our Director General, Marie Chavez, to make the opening remarks.
Thank you, Liz. And I got to use the word Director General. There seems to have been some doubt in the minds of people that you are as a Director General. I am the Director General. I've been duly appointed by the Governor General. My term ends October the 7th next month. So as long as I'm Director General, I will uphold that office. That means that we behave in a fair, transparent manner in accordance to our act. and we have done so throughout this process. Our main interest is the people of Jamaica. We get them affordable electricity rates. And this process has been going on, some people say since 1995. But in recent memory, the thing about gas has been going on since 2003. And there seems to be a kind of expectation that the OUR, a week delay in this sort of process is, to put it mildly, that is detrimental to the interests of Jamaica. We have been working tirelessly on this project. Since March, and remember, we started this project in March. March to September is 6 months. I don't know of any other project in Jamaica that, of this kind of value, over $600 million, that US dollars, that has been completed and a bit of made in so short a time. We have issues along the way, challenges, but we have met these challenges and our staff, we have worked tirelessly. I would like to thank our staff that have been up nights, thank our consultant, Matt McDonald, who have, they themselves are up nights, even at our time when it close of play in Jamaica. They are still talking to us, it means it's 10, 11 o'clock in the UK. And I'm happy that this process is coming to that kind of fruition now. And I will ask Answer you to give an update on all the projects.
Hold on. Just
So we want to thank Mr. Chavez for his opening statement. The Office of Utilities Regulation has been working on several projects simultaneously as it continues its mandate as stipulated in the OUR Act. A part of which states, and I quote, to regulate the provision of prescribed utility services by licensees or specified organizations, to receive and process applications for a license to provide a prescribed utility service and make such recommendations to the Minister in relation to the application as the office considers necessary or desirable, to conduct such research as it thinks necessary or desirable for the purposes of the performance of its functions under the Act, to advise the responsible Minister on such matters relating to the prescribed utility service as it thinks fit or as may be requested by that Minister, and to subject to Section 8A, carry out on its own initiative or at the request of any person such investigations in relation to the provision of prescribed utility services as will enable it to determine whether the interests of consumers are adequately protected. The Regulation, Policy, Monitoring and Enforcement Department at the OUR comprises analysts, engineers, regulators, economists, and other highly qualified technical personnel who conduct the rigorous research and analysis necessary in arriving at critical decisions that have made or that have national implications. So I now invite the director of that department, Ansel Hewitt, to give an update on some of our current projects.
Good afternoon, ladies and gentlemen. I will provide the update by way of a written statement, which I am advised you will receive a copy of after this. In the last 6 months, the Office of Utilities Regulation has been engaged with a number of matters of critical national importance across the regulated sectors. This press briefing presents an opportunity to provide members of the media and the public with updates on the status of some of these matters, and especially on the process for procuring additional generation capacity in the electricity sector, a matter which has been very much in the news in recent weeks. I will begin with the telecommunication sector, which is really always a busy area. And in the last 6 months, it has held true to form. The most significant decision taken by the office in the period, however, was the determination of rates for mobile termination. That decision has resulted in appreciable reductions in calling rates for mobile users and is delivering a bundle of benefits to consumers. In the water and sewage sector. In the water and sewage sector, matters involving new rates for irrigation services and determination of a sewage treatment rate for the Central Wastewater Treatment Company have been on the agenda. The big ticket item, however, has been the application by the National Water Commission, the NWC, for new rates, which has been the subject of extensive island-wide consultations organized by the OUR. That process has involved exchanges between the OUR and the NWC regarding the required information, and there is also some disagreement between us about issues of methodology and other things that we expect to resolve shortly. Indeed, on the last Friday, the NWC submitted comments on the OUR's draft determination decision. Those comments are both extensive and substantial, and are being reviewed as we speak. We expect to conclude that process in short order so that the public can know quickly what, if any, changes will take place with regard to their water and sewage rates. Turning to the electricity sector. Two of the many initiatives that are currently underway and which are of considerable public interest are the evaluation of bids for 150 megawatt of electricity from renewable energy sources, and two, the procurement of base load capacity, or what has been termed rather loosely the 368 megawatt project. As you are aware, the OUR issued a request for proposal in November of 2012, inviting renewable capacity to fill a quota of 115 megawatts. These bids were submitted in June 2013. And going simply on the basis of the number of proposals, there is significant oversubscription, with some 28 proposals submitted by 20 interested entities, amounting in total to a possible 828 megawatt of capacity. Of course, you have to bear in mind that this is energy and not guaranteed capacity. The OUR has indicated that the evaluation would be completed and preferred bidders advised by mid-September. However, because of the unexpected large number of bids and the need to seek clarification from bidders on a number of items as provided for in the RFP process, it has proven impossible to keep that timeline. Nevertheless, all bidders have now been advised that the OUR will issue its decision by September 30th, 2013, a delay of just 2 weeks. Notably, the evaluation of the proposals is being carried out by a local team led by OUR's in-house experts. Not only does this showcase local expertise, but it also provides an opportunity to build up internal capacity. I turn finally to the evaluation of offers for baseload capacity and to the selection of a preferred project, both of which have been matters of considerable public interest and debate. The background to this matter has been well and frequently rehearsed. Notwithstanding, it is important to provide a quick overview. As was indicated by the Director General, Chavez, this process began in March 2013, when in the wake of the termination of a procurement process with the Jamaica Public Service Company to provide 360 megawatt of baseload capacity, the OUR accepted unsolicited proposals from 5 entities. I should pause at this point to underscore that at this stage, the OUR issued no rules for submission, established no processing time, indicated no minimum criteria, and charged no processing fee, as it had no intention of embarking on what could be termed a bidding process. Rather, what the OUR explicitly stated is that it would be examining such unsolicited proposals to see if anyone or a combination of such offers provided a basis to engage the entity or entities in negotiations to supply the required capacity, instead of doing a full-blown competitive tender which would be protracted and the outcome uncertain, given our track record over the years. You may recall that only one bidder responded to the 2010 RFP. As it turned out, only 3 of the 5 entities which made submissions, which the OUR, assisted by an international consultant, McDonald, determined could be seriously considered, given among other things the time frame in which a capacity is required. The OUR had hoped that it would have received proposals that were relatively firm and which would provide a basis for entering into negotiation for an award. As it turned out, however, none of the submitted proposals, including the initial 3 selected, afforded that opportunity. In view of this, and seeking the guidance of the National Contracts Commission, NCC, the OUR concluded that the proposals were at best expressions of interest, and that it could now proceed to draw up what it designated instructions for final proposals, which would allow all the selected entities a common basis for submitting proposals and which would clearly set out the OUR's requirements. Subsequent to receipt and evaluation of the unsolicited proposals, the Cabinet of Jamaica advised the office that it had been approached by a potential bidder whose proposal seems beneficial, and requested that the OUR include this firm in the list of selected entities. Having considered the matter, the OUR, after consulting with and receiving the guidance of the NCC, the National Contracts Commission, concluded that it would set a cut-off date for receipt of any further unsolicited offers, and that if a proposal which was submitted by that date cleared the same threshold as those already selected, it would be included among those to be invited to make final offers. The OUR also took the view that given the need to secure low rates in the shortest possible time, it was desirable to have as large a number of offers as possible from which the best could be selected. By the same reasoning, after reviewing an appeal from one of the 5 entities that had made submission and which was not selected, the OUR included that entity after it indicated it was now in a position to address a critical drawback that was cited by the evaluation. Recognizing the risk that until it had indicated that it was now in a formal process, it would be obliged to consider any proposal submitted that at least met the criteria for those already selected, the OUR advised the Cabinet by way of letter dated May 20th, 2013, that after May 22nd, 2013, it would be closing the window to any further unsolicited offers. The unsolicited proposal from EWI, Energy World International, was submitted on May 22nd, 2013, the last day for which the OUR indicated it would consider any such further offer. The NCC's advice was that any further unsolicited bid offer should be subject to the same process as to that which previous unsolicited offers were made subject. Having received the EWI bid on May 22nd, 2013, and having determined that it met the threshold that was used to eliminate other unsolicited proposals, the OUR determined that it was not practical to halt the entire process to subject this proposal to an exercise that in any event would now have to be repeated for all the proposals. The EWI proposal was therefore included based on the OUR's judgment that it met the minimum threshold and that in any event no proposal could be said to have been placed at a disadvantage now that the office was going to establish clear rules applicable to all in the same way. on May 27, 2013. Therefore, the OUR, after meeting physically and virtually in one instance with representatives, issued instructions for final proposal, what we termed an IFFP, for the supply of baseload generating capacity on a build, own, and operate basis to the following 5 entities: Armorview Holdings Limited, Kingston; EIG Global Energy Partners, Tanquil Limited; Armorview Holdings Limited. Those are the entities in partnership that constitute Armorview Holdings Limited. Azurus Cambridge Joint Venture Association with Waller Marine Incorporated. Energy World International Limited, or Pacific LNG. Jamaica Public Service Company Limited, and Optimal Energy. The IFP included timelines for the various required activities that were very aggressive and in fact departed from the normal period widely established to conduct such activities. But this was driven by such considerations as the imperative of getting capacity in place at the earliest date, cognizance of the near public hysteria in some quarters about the interminable delays that have dogged previous processes, and the expectation that potential bidders, especially those who initially submitted proposals, would be able to quickly refine such proposals. The IFFP process provided for the selected bidders to request clarifications, provide feedbacks, and make requests to the OUR. All the entities, to varying extent, made use of this process to request amendments and clarifications and to make recommendations. As provided in the IFP, all requests for clarification and amendments and recommendations were shared with all entities without disclosing the origin. Consistent with its position that the country needed to have a diversity of offers in order to select the best option, the OUR took a deliberate decision that while staying strictly within the bounds of the IFFP, it would adopt as flexible an approach to bidders as would afford the country the best deal. In this regard, a number of changes were made to the IFFP relating to such matters as extension of times and modification of bid requirements, while at the same time focusing on the objective of obtaining electricity for the consumer at the lowest cost in the shortest feasible time and with reasonable level of security and surety. At the opening of bids on August 8, 2013, submissions were received from 4 entities, viz. Azurus Cambridge Joint Venture Association with Waller Marine Incorporated, Energize Jamaica Limited, incorporating the entities that we previously mentioned, Energy World International Limited, and Optimal Energy. Note that JPS did not submit a bid. Consultant McDonald was further engaged to evaluate these proposals and to provide the OUR with a report setting out the results of its evaluation. The draft report from McDonald flagged a number of issues that required resolution prior to finalizing the report. First matter that required resolution is that the consultant observed that as the IFFP was designed, none of the 4 bidders achieved the minimum score required to qualify any of them in the category ability to finance a project, which would have operated as a filter to proceed to the next round. This was set at 75%. The consultant had in fact made this point in an earlier progress report, but observed in that same report that it was perhaps unrealistic to have expected bidders at this stage to provide the level of financial certainty stipulated in the IFFP. In the circumstances, rather than simply terminating the process, the OUR advised the consultant to proceed to complete both the technical and economic evaluation of the proposals in order to establish a ranking order in the event that the OUR could proceed to negotiate with any of the bidders. The above issues apart, there were a couple of other matters which raised specific questions on which the OUR needed to seek guidance. One of the entities proposed an all-in tariff without providing a breakout of its components. The absence of this breakout prevented modeling and would not have allowed for full economic comparison on all levels. At the same time, the OUR was not sure whether it was at liberty to simply request the additional breakdown of information or simply disregard the bid, especially given the decision to continue the evaluation after all had failed to clear the threshold, financial threshold. 2. Later in the evaluation process, the OUR received communication from one partner in one of the entities that submitted a bid, indicating that the other partner had withdrawn from the consortium. However, the other party indicated in response to an inquiry that while there was disagreement between the partners, it still remained a part of the consortium. In the circumstances, the OUR took the decision that it would seek the guidance of the National Contracts Commission, as has been its practice. The NCC indicated no objection to the decision to assess the submissions, even though none passed the financial threshold, but sought an assurance that the OUR would set clear timelines and criteria for the selected entity to provide assurance of its ability to finance the project. The NCC also had no objection to the OUR assessing the bid that was submitted without a breakout of the components of the proposed all-in tariff, but recommended that the OUR should obtain this information before settling on a preferred bidder. As regards the consortium mentioned above, by the time representatives of the OUR appeared before the NCC, communication was received signed by both of the original partners and a third party, indicating that the disagreement had been resolved and that the composition of the entity remained as had been originally submitted. The NCC therefore provided no comment on this issue. In accordance with the guidance of the NCC, the OUR obtained the required breakdown of the information from the requisite entity, and the appropriate modeling comparison has been done. All the entities submitted proposals with some kind of natural gas solution, but only 2 made proposals which manifested a great degree of certainty. Indeed, 2 of the proposals were for initial startup based on HFO, with natural gas to follow at a later date, as and when gas became available. As a general observation, natural gas-based proposals yielded lower prices than HFO options. So we come now to the issue of the preferred bidder. In the end, the selection of our preferred bidder came down to the ranking of the technical proposals on offer and the lowest price. With regard to technical proposals, it should be noted that all entities received passing grades. As regard pricing, the range of prices varied significantly from a high of US 22 cents to a low of US 13.9 cents per kilowatt hour of electricity. Perhaps at this point, it is instructive to remark that the OUR has computed that the difference in cost to the Jamaican consumer for every 1 cent difference in the price of generation per kilowatt is something in the order of $3 billion annually. Given the result of the assessment, with special emphasis on the points outlined above, the OUR has determined the following ranking of bidders. 1. Azurus Cambridge Joint Venture Association with Waller Marine Incorporated. 2. Energy World International Limited. 3. Energize Jamaica Limited. And 4. Optimal Energy. Azurus Cambridge Joint Venture Association with Waller Marine Incorporated has therefore been designated the preferred bidder. Azurus Cambridge has been so advised. Azurus Cambridge is now required to furnish the OUR with its bid security representing 1% of the total investment cost of the proposed project within 15 days. If Azurus Cambridge fails to post this bond, the OUR will proceed to offer the opportunity to provide the facility to the next ranked entity. We also wish to underscore that this decision is conditional on the completion of aspects of due diligence on the company and its principals, which a financial investigation division is assisting the OUR with. Azurus Cambridge is also required to provide the OUR with unequivocal evidence of its ability to execute the project as part of the lead up to signing the power purchase agreement. Thank you very much.
Thank you very much, Ansel Hewitt. I now open the floors for any questions that you may have. I urge you to make them as concise and brief as possible. Depending on the number of persons wanting to contribute in this section, we may restrict you to one question initially so as to allow as many of you as possible to be heard. Please identify yourselves and the media house or any other entity that you are representing today. I now open the floor for your questions.
Stephen Jackson from the Observer. Just a obvious question. How much is the 1%? And is there any other financial amount that would have to be paid over a certain amount of time?
1% for that project would be $6.9 million US dollars. Yes. And then once the core purchase agreement has been signed, there's a 5% project security that has to be paid. That would be 5 times 6.9. 30 plus million US dollars.
By when again?
Once the power purchase agreement has been agreed and they are going into construction mode, then there's a performance bond.
Oldenburg, Nationwide News.
Can you speak a bit louder so those behind you can hear?
Oldenburg, Nationwide News. I have it on good sources that the preferred bidder yesterday was Energy World International. If this is the case, could you say what exactly occurred to cause them to
There's one conclusion to the project. Yes. So you don't leave the court until the game is over. And he needs fans to recognize that the evaluation process continued up with last time. So anybody gave any information, you go and ask them.
A quick question from me, Dashan Hendricks, RJR. Are you comfortable with the selection process given the concerns raised by the OCG in support to Parliament?
Very comfortable, and we are applying a response, a detailed response to that contractor general, because they continues to be misunderstood despite our explaining to him that we weren't on a formal process, we were accepting unsolicited proposals. And there seem to be two different opinions between the Contractor General and the National Contracts Commission. One is saying that yes, they have no objection for you to do this one, or they say no, you shouldn't do this one. So we decided it was best and most appropriate to the people of Jamaica to have as many and a chance of getting a lower proposal.
So did the minister interfere as much as the OCG said in the process?
Yeah, but I don't interference on the minister, so I don't know what the OCG consider interference and means to make an announcement. We don't consider that interference, we continue to do our work as we set out in our legislation.
And we never interfered beyond just the announcement on April 24th?
The only communication we had was from the cabinet, actually, a letter from the cabinet.
Yes.
My visual is being impaired. Can you just, Dion?
Sorry, can't see you either.
Yeah, you're very short, yeah, just
Dion Jackson, RJR. When you were speaking just now, sir, you spoke about the words I use, I think, the request from the cabinet in relation to considering another proposal. It's an issue that had been raised in the report as well, and in terms of Mr. Chavez's having used the word directive, both verbally, which he then said he then reconsidered to say seek guidance, but then reference was made to a letter as well in which he said the office was given verbal notice it will be directed to review another proposal. I know you gentlemen are very cognizant of the significance of words, and a request, as you would appreciate, extremely different from a directive. Please tell us what was the accurate situation.
Actually, in the evidence given before the contractor general, that issue was also raised, and we indicated that the OUR is a statutory body. It operates according to statutory objectives, and it cannot be directed by the government only insofar as it relates to matters of policy, which is provided for in various pieces of legislation. We clarified with the contractor general that it was not a directive that was given, it was a request, and hence our need to take also guidance from the NCC to consider all the circumstances, including the transparency and integrity of accepting that proposal, and we considered it and included it. So it's not a directive, it's a request.
Could I follow up?
Sure.
You said the office cannot take guidance.
No, cannot.
It should not.
No, that's not what I said. I did not say we cannot take guidance.
No, I beg your pardon, directive.
Directive.
Direction, I do
Right.
beg your pardon.
Yes.
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 Meaning it should not. take
It should
direction.
not. It should not.
Right.
And as indicated before, we are guided by the statutory objectives as set out in the Act. So if a statutory directive or request, whatever it may be, contradicts the OUR's mandate and objective, then the OUR is not obliged to follow that. And the OUR has been at pains, even suing the minister, and went all the way to Privy Council to establish that position. So the OUR at this stage would not resile from that position.
Which brings us back to the letter in which the word directed was used.
What letter is that?
Um,
Verbal notice doesn't connote directive.
The office was given verbal notice that it will be directed to review and
Exactly, it will be directive, but a directive may come, but the OUR has its responsibility and is very cognizant of its powers. So somebody may classify something as a directive, but in the OUR's views, we treat it according to the legislative framework.
Cliff nationwide. Mott MacDonald was hired by you, okay? The rankings that we are being advised of within the last couple of years, do those accord with the rankings recommended to you by Mott MacDonald?
They do.
And that was always so.
We had additional information, as we have indicated. We went to the NCC, we were asked to do additional due diligence, check the information, to model it. So the ranking, whatever ranking at whatever stage was always on the basis of what information was available. What we have as our final ranking accords with the ranking that Mott MacDonald has proposed.
Are you prepared to publish those rankings or summary?
Eventually, we're prepared to submit, to publish a report, yes.
Why eventually?
Because that report contains all kinds of confidential information. We're going to be entering into a process of negotiation. We cannot be handing advantage to the other parties. That may very well have to come in line if this process does not follow through. So we will publish the report eventually.
What was the
but
margin
at this stage,
between the number 1 and number 2 rankings? Did you hear my question?
Yes,
Okay.
yeah, and we're contemplating it because what we have done is that we have deliberately provided a range, because again we do not want to disclose to an entity that we may eventually have to negotiate with what the other offers are that are on the table are.
A disclosure of a margin, it tells
And
the
that's
other
the issue we're
guy
having.
in line how much leverage he has to negotiate if he ever comes to the table. So it's not prudent to even discuss margins.
Could you at least
One
say-
second, Orville. Is there any other question from anybody who has not got the chance?
Some clarifications. Balfour on the observer. Did you
said that the process ended last night.
It was
The
this
president
morning.
this
This morning?
The
You
preferred-
announced the preferred bidder.
Yes.
Process continues.
So at the time when you ended the process, you were already aware of what the contractor general had stated.
Yes.
Did you in any way take that into consideration?
Not at all.
And you do not intend to take that into consideration?
Well, we intend, as the OYR's position is that the contractor general has made certain erroneous conclusions as to the applicability of certain provisions of the procurement guideline. We have in fact requested from the contractor general the verbatim transcript of the proceedings before him because there's pertinent evidence which was not included in that report. And the OUR intend to do a fulsome response to that report and make it available to the public.
By,
So you were still contemplating up to this morning who was your preferred bidder? Were you?
yes, that's what she said.
No, that's not what he said.
We informed the preferred bidder this morning. Until you inform the preferred bidder, you're still in the process.
So when did you arrive at the
That is not
preferred bidder?
important.
Not important, you said?
No, that is not one of our considerations. When we get to a point, we inform the preferred bidder, and the preferred bidder was informed this morning.
When
We-
did you arrive at that position of the preferred bidder?
The position of the preferred bidder was arrived at after we received the results of the breakout and when we did our analysis of that breakout.
When was that?
Well, we received the result of the breakout on Monday. We would have done the analysis yesterday, so we knew yesterday what the situation was. The
So
final
nothing-
situation was
So
yesterday.
nothing had changed over the last 24, 48 hours? You're on the record, please.
Nothing.
Well, I'm
meaning
not-
In
here,
terms of the number one versus the number two ranked bidder.
I think you will recall, Mr. Hughes, that I pointed out that at each stage,
No,
until
I'm just asking a simple
and
question.
Please,
I'm
give them a
answering
chance
me,
to respond, please.
and I'm answering in my simple.
Please, allow them to respond, thank you.
Yeah, I think I was saying that at each stage of the process, the question of whether you had a preferred bidder on Friday would have had to await a process that the NCC indicated that we need to go through. So whatever the consultant would have recommended on Friday would have been contingent on what came out of that further information. Once we have that further information, we had to do the analysis and we arrive at what is the preferred bidder.
On Monday?
Yes.
On Monday, right?
I think I said Tuesday. I said we got the information on Monday. We made the analysis on Tuesday.
Thank you. Any other questions?
Yeah.
Dion, yes.
Clearly from what you've said, if the preferred bidder who has been named can't meet the requirements, it's going to need to be WI. And which is the very company that the contractor general said is going from the process. Now, you spoke of, I think the phrase was near hysteria in terms of the concerns about delay. And I was speaking with Zaki yesterday and he said, yes, they have been concerned about delay. And it is a measure of how disturbed they are by the report that they have called for you to put a hold on the announcement of the preferred bidder. Why not take the time, in fact, to do the fulsome response you said is going to be done, to allow the minister to make his full response, and to allow the issues really to be looked at properly before you went ahead and made this announcement? Why not allow that cloud which is now over the process?
Well, it's not clear to me what turns on the fulsome response. What the contractor general, the report that he has issued, is a report, a historical report that says here is the process.
No, but
We
it's
are
a recommendation.
we are going to respond to that process. We don't agree with the contractor general's recommendation, and we have indicated as much early in the game. So the contractor general says in that report that we did not agree with his recommendation. That position has not changed.
I'm sorry, perhaps I didn't make my question clear.
And also, the preferred bidder, which we have announced today, is not EWI. So what then turns on delaying the process?
The fact that if the preferred bidder doesn't fulfill the expectations, EWI is going to be next in line.
Well, and EWI and Azures has 15 days from today to produce and fulfill its obligations. In that 15-day window period, it would be determined that any cloud over this process would be cleared up by then.
No, I'm afraid I haven't got an answer. Because my question if I could just finish my question, which is that clearly there is still a possibility that EWI is going to become the preferred bidder. In those circumstances, the report of the Contractor General is not just historic, as you're saying, because he makes a specific recommendation in relation to the participation of EWI in this process. Right. Why not delay the announcement and allow that issue to be dealt with?
Well, I think who would deal with that issue? Where would that issue be resolved? On one hand, we have the NCC saying that they had no objection for the inclusion. That's the entity set up to determine how procurement process should go. On the other hand, you have the Contractor General saying we shouldn't have taken the proposal. So who would resolve the issue of whether EWI is in or out?
So is it that at this point you're not the least bit uncomfortable with going ahead in these circumstances?
No, we took guidance for the NCC said there are no objection, and they are following that guidance.
And in addition, just to reiterate the point, Azures from today has 15 days within which to produce a bid security and its financial information to us. That means 2 weeks from today. And as indicated, that within that 2-week lag, this cloud, as alleged, would be cleared up. So if we are to move to the next bidder, then it would be 2 weeks' time from today. So it gives us sufficient time.
Dion, we have to make allowances. Dion, can we give accommodation to another person in the interim?
Of course.
Thank you.
Deborah Barrett from the Green. Just shifting a little bit, the National Water Commission's application for an increase. You said soon, but can you give a more definitive timeline as to when you want to wrap that?
Right. I mean, we'd have loved to have finished this the end of this month. That's what we went home. As I indicated to you, the response we got from the NWC on Friday was extensive. It is a voluminous response, and our people are working on it. So it's difficult at this stage to give you a precise date. But we were certainly hoping at the time that we would have concluded this process by the end of this month. It does look like it will take a little more time than that, given the response we have received.
And just to get back, before Cliff was asking you by what time you would answer the OCG in light of the report he gave yesterday?
As quickly as possible. As indicated, we have also requested the transcript. We haven't received that yet, so I can't give a definitive timeline, but certainly within, it won't be 2 weeks from today that the OUR will be responding for sure.
Question. 15 days to supply the 6.9 million for what is likely to be the largest project ever in Jamaica. Is the 15-year, is that negotiable? If they say that, you know, it's a lot of money, can you give us a week more?
No.
$7 million
Such a security is placed when the bid is submitted.
So it should have been in escrow from before?
Yes, it was an appeal from 3 of the 4 to defer it. Well, some of them to defer it, to delay it, to not include it. We said to 1 no. We said to 2 no. When we saw 3, only 4 was in and they repeated. We figured it was in the best interest of the project to shift it to 15 days after, so that we could get people participating in the process. So 15 days is not unreasonable.
And not negotiable.
Not negotiable either. If you cannot make it in 15 days, then we move on.
Could you say what was the variable in terms of pricing or the overall cost of the project? What exactly accounted for Azures being superior to Energy World International?
We have laid out a whole slew of call and evaluation criteria, and there are many items that we give scores for.
Right.
They do a comparative thing, and put scores, and then we add up the scores. And it's objective. It's objective.
The pricing.
The price?
How they got to the pricing? What if component or everything give them a lower price?
No, I wouldn't be asking that.
What I was saying is what were the variables that where Azurus came out stronger as compared to Energy World?
That's
Another
The price,
one of the ones, the tariff.
the tariff, I mean, all pass they all feel the financial thing, all pass the technical thing, so they all can do the brand.
So it wasn't time, it wasn't any.
No, it's
all of that goes in the scoring. You know, you need to see the evaluation criteria and then it is scored, and at the end of it. But at the end though, there's the economic evaluation, and there you use modeling and dynamic programming. It's a mathematical thing where you plug all the parameters from each other, from the plant, the price of fuel, the price of capital, the capital itself, and all of those things, and you look at a 20-year analysis and look at the net present value of the thing. It's a complex issue. We worked together with Matt to do it. They agreed on the inputs, and then we did the outputs.
Okay, any other question?
Okay.
Question? Yes. I was just asking your response to the, following up on a previous question, the concerns which have been expressed by private sector groups plus the civil society coalition. Do those concerns bother you in relation to the process?
In 16 years at the OU, there is no decision we have made that somebody is not uncomfortable with. Whether it's telecom, one party says no, we shouldn't have done it. If we continue to stop everything we are doing in the nation's interest, we'll never get anything done. We just have a press on. Once we know, we are convinced that we are doing things fair in a transparent manner, we just have to press on.
So you just think everybody else in this is off base except the OUR?
No, I think that's the wrong way to say it. We do apply due diligence, and we do whatever we do within the context of the rules, the policy, the legislation that we are guided by, we are mandated to work with. So when we get to a decision, it is defensible. Now, the parties will disagree, parties will see differently, but we have the comfort that we have done it within the remit and the mandate that we have. So there is no discomfort when we have done it.
I have one final question for you, if you permit me.
Yes, Mr. Hughes.
At the end of the day, the ultimate objective is to reduce our electricity bills. Based on what you have from Azurus to Cambridge, come 2015-2016, what levels of reduction in our electricity bills should we expect?
It's difficult to compute that. You have to know the price in 2016 now to know what reduction you have. So you have one uncertain variable to make that comparison. At present, we just do the evaluation and got the prices. We'd have to take a little while to do the analysis and make a projection of what electricity price would be in 2016 and what possible reduction it might have. So it's
But you said you
no, it's low. Put it this way, it's lower than anything that we have now. The level of reduction, whether it's keep banning out 30%, I don't want to throw it anything about 30% or 25%. But the 13.9 is much lower than even the fuel alone price. In the fuel price alone, much less the cost of a plant today. So we'll see reduction.
Well, what level of reduction you don't know?
I haven't calculated yet.
But isn't that the central objective?
No,
Oh, it certainly is. It certainly is. We have just decided on the preferred bidder.
To secure the reduction.
To get the lowest price of electricity. What you're asking us is to tell you what will be the level of reduction in 2016. And we are saying we have not done that analysis yet. In due time we'll do it, and we
So even in your modeling, you haven't thrown out, you haven't like ran a set of
Yeah.
numbers and said, well, let us assume that the price is going to be X in 2016.
Oh, would that
Then,
help?
So would that,
Yeah, yeah.
would that
So-
have been
But we're not
evaluated?
going to be throwing those figures around.
but
no.
still give an idea of the kind of reductions.
That is a part of
Okay,
the
remind us
scheme,
then
yeah.
how much they are purporting to provide electricity as compared with the estimated
We said
44.
remind you,
Yes.
we did not say.
We gave a range.
Alright.
We
Okay,
did not say.
could you tell us then how much are they proposing to provide?
Yes, you said it was
13 point, yeah, he said.
13.9 cents. The range was 13.9 to 22 cents.
Yeah.
To 20.
That's the
The
range.
text will be available.
But the text will be
But you want, okay. Which is about half what currently provide.
You have to be careful, you know, you're talking about the retail price, is the input price.
Right, but
42 is the retail price, so you have to that 13.9 something, you have to add all the transmission and distribution costs to get it the final price.
So you have no idea where we're going to end up.
They won't tell you how big it is, because you don't like the family.
We did not say we have no idea.
So they won't tell you what to do.
Yes, we have another question.
Warren Burke from Arian Film.
Sorry, could you repeat?
Warren Burke from Arian Film. If the number one bidder does not provide, it does not come down in 15 days and EWI is closed, will any recommendations be made to them to reduce or adjust their plans to make it more cost effective, similar to
In a negotiation, anything is
No,
possible.
what you said, no, you're misunderstanding what you said. We didn't tell the number one to modify this thing to be more cost effective.
No, but I'm just asking in terms of providing a lower cost of energy, since number one bidder was chosen because there were
Or to ask them to come down to number one? But they have been, I mean, they must have been their
No,
cars.
but if they become the choice, I mean,
Yeah, you can't drag everyone to this all option.
We can make a promise, but in a negotiation, anything is possible.
They said I bid that.
The IFFP allows for negotiations to determine final agreements. That may be a consideration, but what the OUR is obliged to hold the bidder to is what they have proposed.
Yeah, and look, or look.
And they can't go any higher than what they have proposed. If they do so, it will be grounds for disregarding their bid.
So therefore you should be able to tell us what rate of reduction we're looking at then. On your modeling.
with the modeling.
We are in this process to get a power plant. We're not in this process now to speculate and whether it's 15.5% reduction, 16% reduction. We did modeling years ago.
Yes.
It is what 19 reduction.
Yeah, but what
we can assure
use
you
is
it's
going to tell you that it's 25 or 26. I don't want to start banning about numbers.
No, you do the modeling already, just don't want to tell us. I find it's changed that you haven't done the modeling. I find it very strange.
Next
We have done
question.
modeling thing.
Next
It's not
question.
dynamic.
Dion, Stephen first, then you, Dion.
I have a quick question. If any of the parties that came second, third, fourth decide to launch a legal battle, would that delay the process?
Well, it
How does
depends.
that go?
Well, it would depend on the courts and the basis, because up until this point, the OUR was obliged not to accept any bids whatsoever. But the preferred bidder having been named, then and informed, then the country, the court will have to weigh the national interest as opposed to that particular claimant's interest. And if that claimant is way down the ranking, and surely that would be a consideration.
Dion, and that's the penultimate question.
This modeling issue, I'm not sure I'm clear. So, yes or no, did you do the modeling? This is A, part A. Did you do the modeling to calculate, to estimate whatever the word project, the percentage reduction? Was that done, yes or no?
That's not a part of this process to choose a preferred bidder. In our general intelligence on what is happening in the energy sector, we have done modeling over the time. But we have to go and re-input those parameters in the model to see what is the new. We have just finished the evaluation, and then it's not a part of the evaluation.
Pricing. When you speak of 13.85 US cents as a law, why that then? And then I hear your lawyer saying that you're going to hold them to that. And they have to come in at that.
No, the modeling is a total different from this process. To determine the level of reduction is not a part of the evaluation process. That's what I'm telling you. To determine the level of reduction is what the OUR would do to satisfy itself that electricity prices come in and give an indication of where electricity price will be going to the market.
That sounds like a direct contradiction of stated policy.
I think you're totally misunderstanding the issue.
As a risk Cambridge had a press briefing recently, and they said, as a risk Cambridge, and they indicated that they indicated that they had a guaranteed price for the LNG, something that is set in stone for some time going forward. So
what?
That must have been put in their proposal for you to use.
No, you don't. I think that's a total misunderstanding of this process.
If they did and it was evaluated, therefore you should be able to provide.
The evaluation has nothing to do with the percentage price reduction. You're comparing one bid against the other bid. To model whether or not you have a reduction, you'll have to know one project and say where prices will be in 2017, what plans will run in 2017, what will be the output of those plans, what the output of the new plans, and compare a thing. That's a separate process from this evaluation process.
And
that is
there's no question about whether there will be a reduction. The question being asked to us is how much will be that reduction? Now, how much is a very quantitative number? They're asking us for a number. We have not done that.
Or give us a range.
No, you can't.
I mean,
wait until we have done it. We are the first one to be informed of it.
Part of the masses.
I just find it strange that you can come to a conclusion without it.
No, because based on what's in front of us.
What was the criteria you selected the preferred bidder if
comparison of two prices, not on the level of reduction.
Okay.
So you have two prices.
Yeah,
and those prices
be used.
Let us put it this way, in a very simplistic manner. You tend to buy 2 pencils, and somebody puts a price of $10 and somebody puts a price of $4. What you do to select your preferred bidder is to analyze the kind of pencils, you analyze the price of those pencils, and depending on who comes out at the lowest price, you select that person.
But the consumer is saying in their head, okay, I'm going to be saving so much.
Yes.
It's a separate issue.
Yes, and it's a separate.
It is now a separate issue. When you ask the question about the reduction of electricity, because you have generation costs, you have transmission costs, you have theft issues, system losses issues, all of that has to be put, and all of that has to be put in the mix in order to come up with a range of reduction. What Mr. Chavis and the rest of the team is saying, in order to do that extensive analysis, it requires a separate process from the process of evaluating a tender as to who has the most attractive
I think
bid.
Mr. Chavis and Mr. Heron are staying away from giving a point estimate, but I'm sure they can give a range.
I can assure you that some objectives will be met if this project happens. There will be diversification of fuel sources in the introduction of a new fuel, and the price of electricity will go down. There will be a reduction. What we cannot tell you today,
so it could be 1%.
No, you don't go 1%, you have to go 100.
And on that note, thank you. We have to wrap up because we are over the time that we have allotted for this. I want to thank you all for coming. And I hope we're able to get your most pressing questions addressed. Thank you and Godspeed.
We don't have a battery. Yo, but stop it.
No, that's
no, that's why I indicated that we hold
What
them
you
to
have,
what they do.
what you have are two pencils at today's price. What you're asking us to do is to do the billing back.
And a projection
And
as
we
what
are not
possibly
prepared to do
2016.
that now because there's so many other variables that you must consider. What the question is, the two variables that you must consider, they have made more than enough today at today's price. You can measure